Uh, the topic is about adjudication and arbitration. Our next speaker is a partner of GAN Partnership, a firm he co-founded in 2011. He's a fellow of the Chartered Institute of Arbitrators from the United Kingdom, the Singapore Institute of Arbitrators, as well as Hong Kong Institute of Arbitrators. He is the immediate past chairman of Malaysian branch of SIAP Arbitrators and sits on the panel of arbitrators and adjudicators of the Asian International Arbitration Center, or AIAC. He is one of the first 10 Malaysian appointees to the panel of arbitrators of the Hainan International Arbitration Court. He also sits on the Securities Industry Dispute Resolution Center, panel of mediators and adjudicators, and is part of the ICC Malaysian Arbitration Committee. He has spent the past 20 years, still young, building upon an active dispute resolution practice in arbitration, litigation, and more recently, in adjudication. He regularly appears as counsel in arbitration at all levels of the Malaysian courts. He has also advised and acted in a broad spectrum of disputes from engineering, construction, power, contract, securities, to company and shareholder disputes. Recently, he has been focusing on construction disputes which involve engineering-related incidents. Amongst the high-profile cases he handled were the highly publicized failure of a hill slope in Penang and a bridge collapse in the Klang Valley. He has also acted in some of the leading cases in construction adjudication, including the first Construction Industry Payment and Adjudication Act of 2012, where the matter was heard at the federal court. Let us all welcome the arbitrator himself for this session, Mr. Fu Jun Liang. Take it away, Mr. Liang.
Thanks, Barry. Good morning, good afternoon, good evening, depending on where you are. The topic that I have for you concerns adjudication. Let me put up the slides on the screen before I shoot off. All right, I hope you can see what I'm seeing. I'll start the slideshow. All right. So my topic for today is adjudication. And the slant that I'd like to give to this topic is whether whether statutory adjudication is just another mode of dispute resolution, or is it a way in which we can reduce and avoid construction disputes? As I go along, you will understand why. For those of you who come from jurisdictions which have statutory adjudication, you'll understand that it's a quick and short method to resolve disputes on construction projects. Right? Let's get into the topic to understand why. Now, what is adjudication? And I'm speaking in the context of statutory adjudication. So this is adjudication that's imposed by law, by state or national legislation. So the first point is that this is an interim measure, and it's an important point, to resolve contractual disputes under a written construction contract. Now, why do we say that this is an interim measure? You are familiar with the construction industry. Think of this as progress payment. So it's interim payment. You can take a construction dispute to an interim dispute resolution process. You don't have to wait till the final accounts. All right. Look at arbitration and court litigation as the final account process, where you sit down at the end and you want a final closure to the disputes on the project. And adjudication is where, during the course of the project, you can, if you do get into a payment dispute, you can refer that dispute to an adjudication, works can go on site and you resolve that particular dispute. It usually involves progress payment disputes, though in Malaysia, our laws allow final account disputes to go to adjudication as well. But let us look at it from the perspective of progress payments. Now, if progress payments are resolved as they go along, whether by discussions over a meeting table or in an adjudication process, chances are that at the end of the project, that gap of expectations between what the employer wants to pay and what the contractor wants to be paid may have narrowed down. It may have been reduced, all right, because of adjudication. And if that gap is not large enough, quite often parties will then look to walk away or look at resolving the final accounts in an amicable way, simply because a full-blown dispute resolution process is not worth the time or the money, all right? And then I take you to the second bullet point, complements other modes of dispute resolution. And this is why, unlike a statutory adjudication process, which depending on which country you are in, may conclude within 3 to 4 months, and some jurisdictions within 2 months, you have a relatively quick dispute resolution process. I will have a chart put up on screen later on comparing adjudications to litigation and arbitration. But you can take it from me now that statutory adjudication is meant to be a quick method for dispute resolution, and it resolves or it brings a resolution in a much shorter time frame as compared to court or arbitration processes. And what does that do? That gives the contractor cash flow, all right? In Malaysia, the statutory adjudication regime has completely taken off, simply because contractors realize how quickly they can get cash flow or get cash into their pockets, rather than to go through a full-blown dispute resolution process like litigation or arbitration. And the moment you have money in your pocket, you breathe easier, the project continues. And you then avoid projects getting abandoned because contractors run out of cash, all right? So in a large way, adjudication complements other dispute resolution processes. And in the example, the illustration that I've given a moment ago, statutory adjudication manages disputes. It keeps full-blown disputes at bay. In quite a number of instances, it avoids the contractor being completely out of cash and abandoning site. It also avoids a problem becoming too large, such that with the best of wills, the contractor cannot complete the project, all right? And you get a decision within a short period of time. Let's look at more of these in a moment. The downside, I suppose, to an adjudication is that it's a summary and informal process. So the phrase rough justice, pay first, talk later, pay first, argue later, are phrases that are bandied about quite often in Malaysia as when statutory adjudication is being discussed. Why this? Much like what happens on site when your contract administrator makes a determination or makes a certification of interim payment, it ain't going to be an exact science. He isn't going to have that ability to count the nuts and bolts down to a cent, all right? So what you'll have is a contract administrator coming to a rough calculation that he thinks is largely fair, because you've got the final account process right at the end where you count the nuts and bolts. In the meantime, what you're looking at is just to line the contractor's pocket with money so that he can continue with the work, all right? So adjudication goes along the same lines. It is meant to give the contractor some cash flow in the course of the project when a construction dispute arises. And when he's got cash in his pocket, he goes on with the work, and you avoid a situation where projects get abandoned. Is this a radical change from litigation or arbitration? So let's look at 4 factors. Where there is statutory adjudication, can you say yes or no to adjudication? Can you say, as an employer, for example, or a main contractor, that you don't want to go to adjudication? If you are responding to an adjudication claim, the short answer is no, you can't. This is a statutory regime that is put in place by the state to force parties or to force a party who has not paid certain sums that are due under a construction contract to go through this process when the contractor makes a claim. Does it resolve and end the contract? No, it doesn't. Quite often, adjudications are taken out in the course of the project to allow cash flow, as I've said. Do you argue your claim or your defense? Yes, you do, but you don't have the full facilities of court litigation or arbitration. It is not going to be a full-blown process, all right? So do you get a full hearing? In some instances you do, but in most instances you don't. The whole idea is not for you to get a full hearing. Very often in Malaysia, statutory adjudication is decided by the adjudicator based on documents only. That is the more efficient way of doing matters rather than to have witnesses attend, expert evidence, and so on. Right, here comes the comparison. Now, on your right column, you see arbitration and litigation, which would be familiar to most of you, even if you've only seen it on television, all right? In a lot of jurisdictions, let's take them one point at a time. Arbitration and litigation is lengthy. Try as you would, court litigation is beyond the control of most parties, simply because courts are not dealing with just your one matter. They are dealing with multiple matters. In certain jurisdictions, it's worse than others, where the courts are completely overloaded. Court matters can take years, all right? A typical construction project would complete 2, 3, 4 years. If the litigation goes on beyond that, you are effectively, as a contractor, financing the entire project before you recover anything. And not very many contractors have the financial strength and financial power to go through the entire project without getting paid, all right? So that's a major downside of litigation. In Malaysia, for example, litigation has improved leaps and bounds in the last 15, 20 years. When I first started practice, I inherited files that have been in court for 10, 15 years. Yeah, a lot of clients whom we acted for on files that I inherited were no longer around. For institutions, you had new officers taking over, and they somehow lost interest in the litigation simply because it wasn't their baby to begin with. You imagine if you are an individual or if you're an owner of a construction company undergoing a contract, would you have the financial strength and energy to go through years and years of litigation? Answer is that you won't. So it's improved significantly in Malaysia. You now have litigation that largely has to complete between 9 to 12 months. That's the unwritten rule. And because most of us court-going lawyers who are involved are also involved in arbitration, very often we are found having to defer to the court processes and the court timelines. So if there's a clash between litigation and arbitration, obviously we've got to give way to court litigation, and we've had to defer our arbitration matters to slot in litigation. So as a result of which, quite a number of us court-going lawyers have experienced a slowdown or a delay in the arbitration process, either because a witness has got to be in court, or one of the parties will have to be in court, or the arbitrator is engaged in court matters. So the arbitration process then takes a backseat and it gets delayed. And when hearing dates are taken off and they have got to be refixed, it's going to be a matter of months, if not a year, before parties actually have got mutually available dates. And the nature of arbitration is such that, barring extreme circumstances, the arbitrator is not going to put his foot down and say, show up on this date, otherwise I'm going to proceed. Very seldom, all right? So you've got the long and short of it, delays or significantly lengthy periods for dispute resolution process when it comes to arbitration and litigation. Adjudication, if it's provided for by legislation, there is a fixed time frame. And again, I'll have a slide on the screen for you to give you an example of what we have in Malaysia. So in Malaysia, jumping ahead a little bit, our adjudication process must complete within 3 to 4 calendar months. I say 3 to 4 because it's largely based on working days. So if you are, for example, at the year end, when you've got festivities and holidays, Christmas, New Year's, it tends to be a little bit longer because public holidays will delay it, all right? Otherwise, you're looking at 3 to 4 calendar months. In other jurisdictions, I think in Singapore and the UK, it is significantly faster. All right. So you get a feel as to this major comparison factor between adjudication and arbitration or litigation. The second is this. As I've said earlier, in adjudication, it's pay first, argue later. So the adjudicator is not going to go into the details of the claim. He's not going to have the time. In Malaysia, for example, from the last document that is filed, the adjudicator has 45 working days to come up with his decision. A lot of us think that 45 working days is quite long, because if you convert it into calendar months, it is probably close to 2 calendar months. There's a lot of time, all right? But we've seen that in adjudication, the documents can be quite voluminous. We've had instances where 8 to 10 boxes of documents are delivered to us as adjudicators for us to sit in the quiet of our own office to resolve and to trawl through. 2 months isn't sufficient time. And if there isn't sufficient time, we aren't going to be able to go through the drawings, look at the as-bills to ascertain how much quantity of work was actually done, compare competing evidence as to what somebody says was the volume of concrete that was used as opposed to the other party. So it's going to be rough justice, all right? As long as what is clear and what is clearly due to be paid to the contractor is determined and ordered to be paid to the contractor. If at the end of the day, in the adjudicator's decision is not accurate, it can still be reopened by the arbitration or litigation process at the end. Our Adjudication Act allows for that. So the arbitration and litigation will be your final account stage by analogy. Your adjudication will be your progress payment stage by analogy. All right. It's meant to line the contractor's pocket with cash. And what's the upshot of this rough justice? Speaking from the perspective of employers, it may prove unduly burdensome to the employer, because certainly in Malaysia, there has been concerns that adjudicators and the public at large look at statutory adjudication as a means to facilitate a contractor's claim. So a lot of employers who we act for have come to ask us whether it's true that the moment a claim is brought in adjudication, it's only a question of how much. All right, and is it a contractor-friendly or contractor-biased process where payment is ordered? To a large extent, you can understand why that is the sentiment, because quite often adjudicators order or award sums that are due, sums to the contractor which may not necessarily be due. All right. Sometimes the adjudicator does not take into account the potential set-offs, like the cost for defective works, rectification, and liquidated and ascertained damages. All right. So if these things are overlooked or not taken seriously by the adjudicator, then you find that the adjudicator awards sums that are not even due to the contractor and this becomes unduly burdensome to the employer. All right. Whereas in arbitration and litigation, there is less excuse for this because it's meant to be a final determination process. So the judge or the arbitrator in an ideal world will have to count nuts and bolts to come to an exact figure. Third bullet point, or third row, less time available for evidence and deliberation. That's a reality. All right. In adjudication, there have been many arguments of a breach of natural justice, simply because the adjudicator limits the number of documents that can be filed or limits the evidence that can be read. Courts in Malaysia and in Singapore and in the UK, Hong Kong as well, largely lean in favor, not yet Hong Kong, sorry, UK and Singapore lean in favor of giving some latitude to the adjudicator, simply because they recognize that the adjudicator does not have very much time. He's got limited time. All right, so he's not able to give the parties the full facilities of a full-blown court litigation or arbitration. So there is no promise for, or there's no assurance that witnesses will be called. There is no immediate right for oral evidence. There is no immediate right for lawyers or party representatives to show up to argue orally. All right. All that it assures parties is that documents may be filed. All right. Rough justice, higher possibility of errors is something that we've already dealt with. I'll jump to the last column. Last row, decision is intended to be interim, can be reopened in a later arbitration. That too I've dealt with. It's meant to facilitate cash flow in the interim. All right. Whereas in arbitration and litigation, it's going to be a final remedy, so it takes time. Let's look at more differences. As I've started by illustrating, statutory adjudication also functions to manage brewing disputes. And let me illustrate this in a little bit more, with a little bit more particulars. Now, let's say I've got progress claim number 1. As the contractor, I'm not paid, or there's a delay in payment. I can probably hold over, hoping that my next progress claim will be paid next month. Comes progress claim number 2, and I'm still not paid, and there's a delay in certification, or there's an under certification. I can then take progress claim number 1 and 2 to adjudication, and that process of 3 or 4 calendar months starts immediately. All right. I continue doing work on site. Dispute resolution process continues in parallel by adjudication. Then come progress claim number 3. I'm paid a little bit. I'm satisfied with it. I leave it alone. Progress claim number 4. Again, I'm not paid. Again, I start a second adjudication. And so now I've got 2 adjudications on foot. The first on progress claim number 1 and 2. The second on progress claim number 4. And so it goes on. Let's say the project completes after progress claim number 30, and I've got 4 or 5 adjudications going on. It's a little bit extreme of an example, but I'm giving you this example to show you how it manages a brewing dispute. So along the way, when the adjudications are on foot, and assuming the employer is still able to smile at you when he sees you on site, the project comes to an end, but you find that along the way, the adjudicator has made decisions. Sometimes he over adjudicates payments, sometimes he under adjudicates. But if you take it in its totality, by the end of the project, that gulf between what the contractor wants to be paid and what he actually has been paid is not very huge. All right. And so the contractor then thinks to himself, do I still want to go through an arbitration or litigation at the end to claim this difference? If the gulf is not that big, chances are that he won't. Of course, if the employer then feels that, oh, I've overpaid this guy, I want to recover some of it, he can go to arbitration or litigation as well, depending on whether there's an arbitration agreement. But if the employer too feels that the gulf is not that big, then that's the end of it. The parties can sit around a table and say, look, let's look at this balanced amount that is due. How are we going to resolve it? All right. The sum is just not big enough to justify a full-blown litigation process. And that's what I mean by adjudication managing brewing disputes. All right. And because cash has been constantly been paid to the contractor along the way, it also avoids the point that I made earlier, a project being abandoned. All right. And that's one of the key reasons or key purposes of statutory adjudication in our country, to avoid projects falling into being abandoned and not being completed. All right. Now, the next line is probably more relevant for us lawyers than anyone else. But the key difference between litigation and arbitration, and I'm talking about litigation and arbitration in Commonwealth jurisdictions, where it's adversarial. Each party puts forward its best foot. Whereas in adjudication, it is largely for the adjudicator to determine the facts and the evidence, so he can play an inquisitorial role. Even if one party is poorly represented or not represented, the adjudicator can be in the driver's seat to elicit evidence, to satisfy himself that this is a decision that he wants to make. All right. Next one is also more relevant for lawyers than anybody else. Statutory adjudication, by definition, is introduced and imposed by statute. So if a contractor takes an employer to adjudication under the Malaysian Adjudication Act, for example, employer cannot say, no, I don't want to go to adjudication. He is bound by law to go to adjudication. In arbitration, it can only happen where there is an arbitration agreement between parties, as King Ho has mentioned before this. In litigation, you can't run away. Someone can sue you simply because he doesn't like the way you look. It's just a matter for the courts to make a decision and to come down hard on the person who files a frivolous suit. All right. Second last line. This deals with the impact of statutory adjudication. In my view, I think it disciplines consultants, because in very many instances, consultants are a little bit tardy in the certification process. Tardy in terms of looking at the details, tardy in terms of timing. Most boilerplate construction contracts, standard form construction contracts have got timelines for the certification process, be it 14 days, 28 days, 30 days, or what have you. All right. In a number of instances that we look at, consultants don't abide by that. But if you have got a situation where the contractor takes the employer to adjudication and claims interest for the delay in the certification or claims for under certification, and if the employer then ends up having to pay interest and ends up having to pay the cost of the adjudication, which is not low, it can be in the tens of thousands in Malaysia, then you have the employer looking at the consultant and asking the consultant, why on earth did you take so long to certify? And why did you expose me to all these claims for interest and costs? All right. That, of course, is in an ideal situation where the delay or the tardiness on the part of the consultant was not under the influence of the employer. All right. So to me, it disciplines consultants to some extent, and it also exposes the consultants to professional liability. Because if I'm the employer and my consultant has delayed in certification or is grossly under-certified, resulting in an adjudication claim against me, and then I end up having to pay interest and costs on the adjudication, I will look to my consultants and ask him why. Why shouldn't I come after you for the interest that I've incurred, for the under-certification, and for the cost? All right. And the last point is common to adjudication and arbitration. They are confidential processes. Not so much litigation in the Malaysian courts, but certainly adjudication and arbitrations are confidential. All right. Now, I've used the word CIPA. CIPA is the abbreviation for the Construction Industry Payment and Adjudication Act in Malaysia. It was introduced the Act is dated 2012. It's a 2012 Act, but it came into force in 2014 in Malaysia. And we have seen huge developments in terms of the law of statutory adjudication in our country. All right. So I'll take you through some of the key features for you to understand how statutory adjudication functions in our country, and it largely follows other jurisdictions as well, except in one or two key areas. Now, in Malaysia, I will not take you through the statutory provisions. This is the boring part of it. The slide on the screen just tells you that statutory adjudication applies to construction work and construction. So it's construction work contracts and construction consultancy contracts. So it's not only for contractors' claims. If you are an architect or you're an engineer on a construction project, or even a lawyer advising on a construction contract, technically you can bring a claim on your fees as well as a consultant. All right. And so these provisions that I've lifted from our CIPA Act gives you the definition of what amounts to a construction work contract and construction work. You can see that it's very widely worded. And here is a construction consultancy contract, which speaks about consultancy services. So this is interesting because it's not limited to a typical claim between the people doing the work and the employer. It involves the consultants as well. All right. So consultants who are not paid can also take the employer or whoever employs them to adjudication. And in Malaysia, these claims have largely been successful, right, if the statutory requirements are met. All right. Now, this is to give you a feel of the timeline. The entire adjudication process that is provided for under our Malaysian Act is set out on this screen. And there are discretionary steps that may be ordered by or directed by the adjudicator. Those are not stated here. But assuming that there are no discretionary steps that are directed, This is a typical process. The claimant starts with a payment claim. The respondent has got 10 working days. The identification of days on the left column would be calendar days. So he's got 10 calendar days to respond to the claim. All right. If he does not respond or he responds in part, we will look at the consequences later in a later slide. Then once a response comes in, assuming that the response says, go away, I'm not going to pay you, or I'm not going to pay you in full, then the claimant, let's call him the contractor, has the option of proceeding with a notice of adjudication. That step is usually taken together or back to back with an appointment, a step for the appointment of the adjudicator. All right. So the notice of adjudication is issued, and parties then have the option of either agreeing who the adjudicator is, or in the absence of agreeing the adjudicator, to go to an appointing authority. In Malaysia, it's the Asian International Arbitration Center, the AIAC, that makes the appointment of the adjudicator. And so depending on whether it's the AIAC to appoint or whether it's for parties agreement, it's 5 or 10 working days for that appointment. Once the adjudicator has been approached and he accepts the appointment, he has got 10 working days to accept the appointment and to work out the terms of his appointment, right? So once the adjudicator then is appointed and his appointment is confirmed, the claimant then has 10 working days to issue an adjudication claim, all right? That adjudication claim largely reflects what is in the payment claim. It has got to be limited to the claims in the payment claim, but it can include evidence. It will include evidence, supporting documents. The payment claim usually does not come with supporting documents. So the adjudication claim will have the supporting documents. Within 10 working days, the respondent, the employer, has to put in his adjudication response, and the contractor then has 5 working days to reply. That is in the adjudication reply, if any. Then the adjudicator will have 45 working days to come up with his decision. All right. This is in the ordinary course, barring any discretionary directions of the adjudicator. Quite often, as a way to delay proceedings, for example, the respondent, the employer, upon receiving the adjudication reply, that's the second last line, will say, Mr. Adjudicator, can you please allow me to put in a further response, a rebuttal, a joinder, whatever he calls it, he wants to put in a further reply. Or can you please direct oral evidence to be led, or can you please direct for witness statements to be submitted? All right. So this happens depending on which side of the fence you are on. If you are claiming, of course, you want the process to be adhered to as strictly as possible because you want that decision within the 45 working days. Invariably, if parties file too many documents, or if there is oral evidence or witnesses who are called, then you inundate the adjudicator with too much information, too much documents, that 45 working days may not necessarily work. The adjudicator will come back and say, can I have more time? Then it is for the parties, whether the claimant or the respondent, to decide whether they want to give them more time. Okay. Now, as to what the consequences may be, let's look at it later. So pay first, argue later. And it is important to note that in adjudication in Malaysia, the payment that you can claim for is defined under the Act. So it means a payment for work done or services rendered under the express terms of the construction contract. So this would be something that you're familiar with. You can make a claim in adjudication for work done. That is the typical phrase that is used. But you can't make a claim for damages, right? So that's the distinction that needs to be drawn. If you want to make a claim for damages, you will have to take it to arbitration or to litigation. So in Malaysia, and indeed in most jurisdictions, when you're looking at construction claims, you look at the phrase loss and expense. So the $1 million question then is, can a contractor bring a claim for loss and expense to adjudication? There is no precise answer to that. It depends on what are the categories of claims that go under the loss and expense head. All right. If what is claimed is for work done, then answer is that you can. If what is claimed for is for damages, you can't. All right. So that's one qualifying factor for a party to go to adjudication. Now, I did speak about an adjudication decision being interim. Section 13 of our Act makes this very clear. So let's say I'm the contractor. I've succeeded in the adjudication. I'm sitting on an adjudication claim, or sorry, an adjudication decision for you to pay me X amount of dollars. How long does that adjudication decision stand for, and until when? The answer is in Section 13. It remains binding unless it is set aside. Obviously, if someone takes a challenge to court and the adjudication decision is set aside, that's the end of your adjudication decision. Second, if the subject matter of the adjudication decision is settled by a written agreement. So between you and I, we settle it. Assuming the adjudication decision is for you to pay me X dollars, we agree to Y dollars, and it has got to be in a written agreement. It's taken as settled. The adjudication decision is no longer binding. And the last is where you take it to the final determination process, either by arbitration or by court. All right, that was the analogy that I used earlier, arbitration and court as the final account process. Okay. Now, let me just go back a little bit. If you look at item A, an adjudication decision ceases to be binding if it is set aside by the High Court on any of the grounds referred to in Section 15. Section 15 provides only 4 grounds to challenge an adjudication decision. All right. I will not bore you with the details. Just take it from me that there cannot be a revisit on the merits of the claim. So the courts in Malaysia and indeed in most other countries are very clear. Even if you can show that the adjudicator has wrongly counted the nuts and the bolts, he's made a factual error, he's made a legal error in terms of the law, you cannot challenge the adjudication decision. It's a policy decision, or it's a policy direction for it to be, for adjudication to be more expeditious. You can't challenge it. You can only challenge it on these 4 grounds, and these are 4 procedural grounds or on overriding principles. So obviously, A, if you can show that the adjudicator has, or the adjudication decision was procured either by fraud or bribery. In all the years that I've seen CIPA functioning in Malaysia, I've not come across anyone who's able to prove fraud or bribery. All right, so good luck to you. Second, breach of natural justice. That happens quite often, all right, because not all adjudicators are attuned to the legal principle of natural justice, and it's very basic. So when I speak to one party, I can't speak to that party in exclusion of the other. Both parties must be communicated to simultaneously, and there cannot be unilateral communication with one party and not the other. All right, so that's a common fault adjudicators commit. Another common fault is for an adjudicator to apply his own knowledge without telling the parties. All right. So, for example, I as adjudicator say that, you know, typically concrete prices in Malaysia are X amount of ringgit per cubic meter, and I disregard all the evidence that is given to me. All right. I'm entitled to use that specific knowledge because this is what CIPA is about. I'm supposed to be a specialist in this area. I can apply my own knowledge, but I've got to put it to the parties to tell me whether my X amount of ringgit per cubic meter is correct or it's wrong, because I may have been out of touch with reality, right? So that's the natural justice point. C, whether adjudicator has not acted independently or impartially. It also happens sometimes because we are all human beings and we have our failings as human beings. So if I've taken a dislike to one party, and quite often adjudicators, arbitrators, and judges do, the problem is when you don't bite your tongue and you say, or you behave and you betray the fact that you have taken a dislike to one party, or when you allow one party to file a document and you don't allow the other party to respond. Those are examples of the adjudicator not acting independently or not being seen to be acting independently or impartially, or where the adjudicator acts in excess of his jurisdiction. Also happens to the best of us. Sometimes we lose our eye on what was actually submitted to us, and we deal with something beyond what was submitted to us, and that is in excess of jurisdiction. So those are the 4 instances when adjudication decision can fall. All right. So bear in mind, none of these are can be challenged on its merits. Now, there is a separate ground that is not in section 15, and it's in section 12.4, where there's a requirement for reasons in an adjudication decision. Now, I've been on, I've tried taking a challenge under section 12.4, obviously where I've acted for the developer and I failed. An adjudication decision was made against my client, the developer. And I've not been able to bring myself under one of the section 15 grounds, A, B, C, or D. But it occurred to me that the adjudication decision was a little bit scanty in terms of reasoning. It was a one-liner, all right? And so I tried to take that challenge. But I was given short shrift. The long and short of it is that said, look, Mr. Fu, one line is a reason, one paragraph is a reason, 10 pages is a reason. Just because it's a one-liner doesn't mean that it's not a reason, all right? So I'm not going to second guess the adjudicator. I'm not going to allow your application. So that to me was more of a policy decision of not interfering with adjudication decisions. I can understand it, but the question then is, at what level do we say that no reasons were given? What is the benchmark? What's the threshold? Because if you look at Australian cases, for example, the various states of Australia have been very robust. So if you give reasons and the reasons don't make sense, if they are detached, if it's difficult to understand or it's illegible, courts have found that these do not amount to reasons, all right? So it remains to be seen in various jurisdictions whether they are going to be as robust as the various states of Australia. Certainly in Malaysia, we have not been, all right? So if there is a complete lack of reasons, for example, this is the extreme end, then this is certainly one ground to challenge an adjudication decision. Now, I did say that adjudication also complements arbitration and court processes, but the question is whether it's better than a court judgment. Answer is that it is. With a court judgment, you can't suspend works, right? With an adjudication decision as a contractor, by law, you can suspend works, and you can't, the delay for the period of suspension cannot be attributed to you as the contractor. That's section 29. Section 30, separately, if you are a subcontractor and you've got an adjudication decision against the main contractor, section 30 allows you to go directly to the employer for direct payment. All right, this is of course on the assumption that the employer owes the main contractor money. All right, and there are prerequisites for section 30. I'll not bore you with that. Now, in the last segment, what I'm going to do is to take you through some of the key decisions in Malaysia on our act, just to give you a flavor of how the courts have approached it. And I'll get through this fairly quickly. Now, this is a case on direct payment. Now, in the example that I've given you earlier, when the main contractor doesn't make payment to you as a subcontractor on an adjudication decision, you can go directly to the employer, all right? In this case of City Indah, it was a peculiar situation where the main contractor had been wound up in the meantime. So the argument in company law is that monies that are due to the main contractor by the employer has got to be paid to the liquidator of the main contractor to be distributed amongst its unsecured creditors. So the main contractor, the employer then cannot make direct payment to the subcontractor. And so the High Court felt, but the Court of Appeal reversed that, and this was upheld by the Federal Court. So the long and short of it is, if notice for direct payment was issued before the main contractor was wound up, the subcontractor may well be able to get direct payment from the employer, even if the main contractor is wound up. All right. I know it all sounds a little bit convoluted, but this is another benefit of a Section 30 direct payment. There have been attempts to declare CIPA as being unconstitutional, as taking away the rights of the courts to determine disputes. Now, this is a case which decided that CIPA is not unconstitutional. It does not take away judicial power that is vested in the courts, all right? So CIPA is enforceable in law. In Malaysia, statutory adjudication can only be taken out in respect of contracts that were signed after the 15th of April 2014. That is the date on which SEPA came into force. So it's 15th of April 2014. If you've got a contract that was entered into before the 15th of April 2014, you do not have access to statutory adjudication in Malaysia. Martego stands for two important principles. The first is that SEPA is also applicable or can be used for final accounts. All right. Now, this came into being because of the initial thinking of what the initial rationale of what SEPA should have been about, to facilitate cash flow during the course of the project. Now, when the final account is out, the project is completed, why else do you need adjudication? But Court of Appeal and Federal Court in this case looked at our act and said, look, there's nothing in the act or in the parliamentary debate that says that this act is limited only to interim payments. So it applies also to final accounts. And Martego is also a clear case or a clear example when architectural firm Myo and Chus and Duran Berhad could bring an adjudication claim for its consultancy fees. All right. Now, an adjudication decision can also form the basis of a winding up action against the respondent in the adjudication. You need not convert that into a court judgment. You can go based on an adjudication decision itself. So Likas Bay was a Court of Appeal decision which held as such. At the bottom of that page, Sime Darby Energy is a second decision, a more recent decision, which followed that. Of course, there are exceptions. If you can establish a cross-claim, a substantial cross-claim that exceeds the adjudication decision, or casts a genuine dispute over the adjudicated sum, the courts may well prevent you from going for a winding up based on simply an adjudication decision. But the law generally is that you can. All right. Now, other things that you need to know, View Esteem is a 2019 decision. It still holds true today. It basically renders a payment response. If you remember the flow chart that I've given you earlier, this is the second stage in the adjudication. View Esteem basically says that without a payment response, the respondent is not at a disadvantage. Prior to View Esteem's decision, the general understanding, as was the position as is the position everywhere else around the world that has got a statutory adjudication, a payment response or its equivalent is absolutely necessary. If you don't put in one, or you put in a half-hearted one, you may well be caught out and you may well be limited by what you have said in your payment response. View Esteem says no, you don't have to put in a payment response. Even if you put in one that has limited defenses, you can expand and put in other defenses later on in the course of the adjudication. Now that, in my respectful view, is clearly wrong. Or I shouldn't say that's clearly wrong, because this is a pronouncement by the Federal Court. Federal Court cannot be wrong because it pronounces the law. But that takes, this certainly takes us away from other countries practicing statutory adjudication. And earlier, when my CV was read out, I think I was introduced as having dealt with the first statutory adjudication or SEPA decision that went to the Federal Court. This is it. All right. Unfortunately, I was on the losing end. Section 16, the second bullet point, this case also says that the test for granting a stay of an adjudication decision is wider than what was previously understood. Previous to this case, it was understood that you can only get a stay of an adjudication decision where you can show that having paid on the adjudication decision, you will not get repaid your monies if you succeeded in court or in arbitration thereafter. All right. That was the high standards or the test that was implemented in the UK, in Australia, in Singapore, and so on. Very little circumstances beyond that where you can get a stay. But in the wisdom of our federal court, they said that that's too restrictive. It's wider. So View Esteem says that you can go beyond that. Our subsequent court decisions have tried to contain this can of worms, all right? But that's what you have now. Now, key points for developers, which may not interest you very much, be prepared for a surprise. A lot of developers have faced claims by statutory adjudication because contractors have come to realize It's only a question of how much I'm going to be paid the moment I start an adjudication. All right, it's biased towards the contractor. Developers will also need to keep contemporaneous documentation and keep them well. They will also need to issue the contractual notices, like your certificate of non-completion and so on, that are required under the contract before you can issue a set-off. These are important. Now, what defenses are available? Generally, set-off for defective works, liquidated damages. So when we speak to developers, we remind them that they need to get the paperwork in place to set up these two set-offs, just in case they are hit with a claim in SIPA. And the last bullet point is be mindful as to when a dispute has arisen. As the developer, you may well have to be in the driver's seat by starting a claim in court or in arbitration, depending on what you have, so that when a claim in SIPA comes, you can use the court process or arbitration to neutralize the adjudication process. Now, what may be more relevant to you as contractors would be this. Certainly, you need to have evidence when you bring your claim. From our experience sitting as adjudicators, quite often contractors dump on us boxes of documents without explaining to us what the documents say. Or they will say, box 1 is a document on progress claim number 1, expecting us to trawl through it and match the documents to the progress claim. So the burden of proof is on the contractor. Explain your evidence if you're bringing a claim. And as the contractor, bear in mind that view esteem, that federal court decision that I was speaking about just before this, does not help you because it does not require the employer to put in a payment response. The employer may well, as a payment response, respond by saying, I'm not paying you because I don't like the way you look. All right. And when the adjudicator is appointed, he will dump 20 boxes of documents on you with a full-blown adjudication response, leaving you 5 days to respond. So this view esteem prejudices the contractor in that way. And lastly, be reasonable with extensions of time. You recall when I was going through the flow chart of the adjudication process, the 45 working days for the adjudicator. When the adjudicator is inundated with evidence and with documents, he might ask for an extension of time. Quite often, when I'm acting for a party, I will say yes, provided it's a reasonable extension. Not another 45 days because that doubles the time. Another week, another 2 weeks, livable. All right, because you've already gone through a 3-4 month process. You're just waiting another week or so. But I've had instances where parties come down hard and say no. All right, and they cite the rationale of statutory adjudication and so on as an answer. It can be counterproductive. Number one, you will give the adjudicator very little time to look at the evidence. He may get it completely wrong. And more devastatingly, in one matter that I did, where I was the respondent, I was quite happy to give the extension of time. Claimant came back and said no. All the adjudicator was asking for was 2 weeks, and he was on his last week. So we had already gone through about 3.5 months of adjudication. Adjudicator simply sent an email and said, I hereby resign. To me, that would be completely devastating to the claimant, who had spent 3.5 months in this process, who only needed to spend another 2 weeks. Adjudicator says he resigns, and the adjudication process will have to start afresh. We wasted our time and money. Okay, so be favorable. Oh, sorry, be reasonable. That brings me to the end. I think Q&As will start or will be taken at the end of the last session. Thanks, everyone.
Thank you so much, Mr. Pu Junliang. That was indeed very insightful as an expert in arbitration and adjudication.